And the order with regard to the scheduling is that paper discovery and production of documents were to be completed by September 9. Fact discovery, depositions, non-expert depositions by December 16. Plaintiff's expert report by February 17 of 23. Defendant's expert report April 14 of 23. Expert discovery depositions by June 17 of 23. Motions for summary judgment August 11. Brief in opposition 28 days thereafter. Reply briefs 7 days thereafter. Motions in limine by December 18th. Trial is scheduled for January 8th of 24. And there have been numerous ongoing discovery disputes. And several orders have been issued. And the reason you're here right now is because the disputes continue despite the orders. So let's start with you, Mr. Sebastiano. What's going on?
Good morning, Your Honor. Adam Freed here for
I'm sorry, Mr. Freed.
That's okay. Thank you for having us here today. We are beside ourselves in the context that we can't get documents that we've requested, demanded, and that this court has ordered. The most recent order was met with a response with some spreadsheets that a Vestige firm had identified, sends us the spreadsheets and essentially says, pick what you want. Some of the spreadsheets are indecipherable. We were supposed to have gotten a full and complete responses to the discovery interrogatories. I give the court a very brief example because I think it's important to understand why we're asking for information that we're not getting. In our interrogatory number 6, it states, please state whether you ever described, stated, articulated, and or expressed concern that decedent suffered from one or more illnesses, conditions, and or diseases which interfered with the decedent's cognitive function and or ability to remember things. That's just a component of it. Then it asks for, note this interrogatory does not intend for you to render any medical diagnoses, etc. We have text messages between the defendant and the decedent's daughter, where the defendant, Laura Novak, says, I think your father really is in the beginning years of Alzheimer's because he can't remember anything unless he chooses, perhaps that's another reason. This is something that we would typically wait to use in cross-examination. We believe that the defendant has been texting and emailing other people. We've been told that she doesn't use the computers, yet we're now being told that there are a significant number of emails. The reality is we cannot adequately prepare our case for depositions, for going forward to be able to present our case to a jury, to be able to respond to motions for summary judgment. This is really the most I went through all of these discovery issues preparing for today. Nick has been, Mr. Sebastiano, has been handling the detail, and I'm so thankful that he's been handling the detail because I'm looking at this and I cannot believe the responses we're getting.
So what's the answer to number 6?
The answer to number 6, Your Honor, after the court overruled the objections, the defendant objects to this interrogatory as it seeks information that is not relevant to any claim or defense of any party to this litigation, and it is not likely to lead to discoverable documents and or information. Defendant further objects as to relevancy as to the sale of the Amberwood house as it relates to the decedent's medical history, which is confidential. Then she goes on to say, Frank Novak was extremely able over the years, handled all financial affairs, including the sale of the Amberwood house. As his wife, I helped him from time to time, His ability to deal with day-to-day matters, problem solving, was still much better than most. Frank Novak still drove and did shopping, and even shopped earlier in the day of the date he passed. His former wife and family members of Frank were aware of him having a quadruple bypass and other medical assistance over the last 40 years. Due to his heart concerns during the COVID crisis, contact was limited during the COVID era based on government recommendations. It completely ignores the subject of her having even expressed to family members that she believed he was suffering from Alzheimer's or early onset Alzheimer's.
When was that answer provided?
This answer was provided, Your Honor, I believe under cover of, well, I don't want to misrepresent it. It's attached to a letter of November 14th, 2022, but let me look at the date on the back. It was notarized, Laura's signature, the defendant's signature was notarized November 14th, 2022.
Okay. Now, why wasn't that interrogatory answered, Mr. Brule?
Your Honor, good morning, and I apologize that Mrs. Novak's not here. She's on her way. I called her. That's my mistake. But that interrogatory was answered.
It was not answered, okay? What was that question? Tell me that question again.
The question to number 6, please state whether you ever described, stated, articulated, and/or expressed concern that decedent suffered from one or more illnesses, conditions, and/or diseases which interfered with the decedent's cognitive function and/or ability to remember facts.
Okay, did she ever express that to anybody?
I had not.
Hold on. First of all,
Yes.
the question was ignored. That answer does not pertain to that question. The question is whether she expressed that to anybody.
I have to say I'm not entirely positive. I have seen one text message.
Okay, here.
Has she ever expressed it to anyone?
The answer simply is yes, she has, or no, she hasn't.
Well,
Right?
He was 83 years old.
I know how old he was. I know more about this case at this stage than I ever want to know about a civil case at this stage, because we're not scheduled for trial for another 54 or 55 weeks. Okay, I know more about this case than any case I've had in 8 years that I've been sitting here. Okay, and the number of these type of hearings we've had to have on civil cases is probably counted on one hand. Okay, so the question is, has she ever expressed that?
I saw, the answer to that, Your Honor, is that I have not heard it from her lips, and I asked her about that.
Okay, so why didn't she say then, I don't care what you heard from her lips, the answer to her, or the question to her, has she expressed this? She can, she's perfectly capable of answering these interrogatories.
She is.
With your guidance,
She is.
okay? So whether she told you that or not is not the issue. Whether she told that to anybody else is the issue for the purpose of discovery.
Well, I think what happened in the case that Mr. Fried is pointing to is that after, there was in March of 21, there was an exchange with Ruth Novak Jr. by text, something on memory and stuff. There was a text message on it. We didn't see it after the case. I've seen it now. And I've asked for the text messages.
This goes beyond what I'm addressing.
Oh, yes, sir.
I'm simply asking, why didn't she answer that question? And didn't I order her to answer that question?
Yes.
Okay, you objected after I overruled the objection, correct?
Well, I had a continuing objection as to...
Okay, I overruled it. Okay, I mean, this process is in the discovery phase. The plaintiff sends out some interrogatories. The defendant is to answer the interrogatories. If the defendant wants to object on some basis, the defendant objects. It comes to my attention, I rule on the objection. Once I rule on the objection, then that's the end of it,
Okay.
okay? So this is, so I guess the question again is, why didn't she answer the question? Because she didn't want to answer the question, right?
No, I don't think that's true, Your Honor. She doesn't know that he had Alzheimer's.
I didn't, the
Okay.
question is not whether he, and specifically, they're leaving out they're not asking her to diagnose him, okay?
Right.
They're asking simply whether she communicated this to individuals. Not whether he had Alzheimer's, not her evaluation of his medical condition.
Right.
Or psychological condition, okay? It's a very simple question. She may not like the question, okay? I mean, the gist of this case seems to be, and this is set out in entries throughout this case, that he was perfectly fine 10 days before he died and the house was transferred in Florida. And if you want answers to these questions, then you got to prove that he wasn't perfectly fine, right? Isn't that kind of what your position has been?
Well, the counsel has to prove that he has Alzheimer's or something, but...
See, but we're in discovery,
Yes, sir.
okay? Anything that's relevant or can lead to relevant evidence is fair game. I think
I
I've said that
I agree.
a whole bunch of times, okay?
I
So
agree.
they don't have to prove that he was unduly influenced before they attempt to prove on January 8th of 2024 that he was unduly influenced,
Yes, sir.
okay?
So
There's no excuse for her not answering interrogatory number 6, especially after the objection was overruled. And so this is only, what's today, the 23rd? This is 10 days ago that answer was provided?
Yes, sir.
Okay. Why? I mean, what escapes your client at this point as to that question specifically?
She doesn't know he has Alzheimer's. There was...
Listen.
I'm sorry.
Listen, I don't care whether he has Alzheimer's at the time he died or didn't have Alzheimer's at the time he died, okay? There's one or two reasons that she doesn't answer that question, okay? Well, actually, there's one reason. At this point, there's one reason, because the question is simple. Did she communicate this, okay? The reason she doesn't answer it is because she doesn't want to answer it. And why she doesn't want to answer it, I don't know. Is it because she had some communications? That seems to be the logical conclusion.
What I thought would happen, Your Honor, was that they were going to take her deposition and they could ask her those questions directly with the documents that they have.
I'm going to assume that that's exactly what they wanted to do, okay? But the reason, what did I tell you? That the fact the paper discovery was to be completed September 9th, it was to be completed. Fact depositions were to be completed some 3+ months after that. And the reason I did that, and the reason I almost universally do that in civil cases, is that a lawyer wants information
Yes.
in discovery before he takes a deposition of a party. And so your assumption that they're going to ask that, they're going to broach that subject at deposition is completely 100% accurate, okay? That doesn't mean that they're only entitled to find that out at the deposition and not in written discovery, right?
Your Honor, I think that they're speaking of a text message they went to Ruth Jr. when there was a argument talking about her father when she was drinking.
I don't care about that.
Okay.
Okay, I don't care about the message to or from Ruth, the daughter. I don't care about that.
Okay.
I care about the answer to the question that was asked. That's what I care about.
We do as well.
What?
We do as well.
Well, if you did, then the question would have been answered. The question was not answered.
If she didn't recall that he had that, or didn't think she had it, that the answer is correct.
It didn't have what?
Alzheimer's.
Or
Medical conditions.
Mr. Freed, read me that question.
Yes, Your Honor. Please state whether you ever described, stated, articulated, and/or expressed concern that decedent suffered from one or more illnesses, conditions, and/or diseases which interfered with decedent's cognitive function and/or ability to remember facts.
Okay? There's no word Alzheimer's in there. Okay? The question is not whether in Laura's mind he had Alzheimer's. The question is whether he ever stated those concerns to anybody else. That she either did or she didn't. If she didn't, then it's a one-word answer, no. If she did, then it's a one-word answer, yes. That's it. That's it. Okay, now, so there's no reason for that answer to be attached to that question.
Okay.
All right, so this is the kind of things that have led us here at 7:30 on November 23rd. Okay? Now, Mr. Freed, what other discovery concerns, and I'm going to get to you, I'm going to allow you to tell me what concerns you've had also, but Mr. Freed, go ahead.
Your Honor, that was just one example,
I understand.
and I appreciate the indulgence. Documents, I'll get to in a minute. Now I write things down, and I gotta find where I wrote it down. Okay. Another example is paragraph 13, question number 13. Where this is a very simple issue. Please describe all instances where you and decedent got into a fight and you left your home and stayed away from decedent between March 20th, 2020 and March 29th, 2020 and March 29th, 2021. So a year's time frame, all in the relevant time frame of the sale of this Florida home. Again, there was no fight. I was very frustrated that adult children were trying to use their father as their personal bank and taking advantage of his generosity. There were disagreements from time to time. I stayed at a nearby lodge for 2 nights. We have, again, a text message describing this fight, which is very relevant in the time frame of the sale of the Florida residence.
What was the date you're on? Who's the date, Counselor?
At March 10th, 2021, this is text messages to the decedent's daughter, Ruth. I will not tolerate money being relieved of my personal account to give to Dwayne. And if your father does it, I am done with him. Further on down. And your dad wants to write a big check out of my and his personal account. Okay, I hope it's worth it because you just lost your wife. And then, further down, your father needs to take care of the cats and whatever, take his pills. Oh, don't worry, I've already taken care of all that for the next week. Other than that, I'm going to say goodnight because I'm just enjoying my time in the hotel. And elsewhere in this text message, she talks about leaving the decedent. A couple other issues. Question number one. Which is similar to number 6, where we asked, did she believe that he suffered from conditions? And the question itself is, please list and or describe as specifically as possible all medical ailments, conditions decedent was diagnosed with or believed to suffer from during the last year of decedent's life, including decedent's last illness and cause of death. Plaintiff is aware, this is the answer, after the objection, same standard objection. Plaintiff is aware of his early medical history. Plaintiff's counsel has Frank Novak's personal and confidential medical records from the Cleveland Clinic. The defendant had follow-up issues over the years regarding his heart. It is the defendant's understanding that one or more stents were used, catheterizations, anesthesia, and pacemaker were used or placed over the years. There was no autopsy at the time of his death, of which I am aware. The death, as I understand it, was related to his heart, perhaps age, of course, and possibly a reaction to the COVID vaccine. Frank Novak lived an extraordinarily long, productive life, likely one of the best success stories of the bypass surgery he had in his 40s, yet lived well into his 80s. Frank Novak was still driving his personal car and even went shopping on the day of his death. He never stopped his life. What makes the answers, in light of the text messages that we have, particularly troublesome is the evasion of the production of the text messages, the emails, the refusal to search all of the email documents, all the email accounts that we know, we believe we know Laura Novak had, because it leads us to understand things that are different. If we didn't have these text messages, we would be at a disadvantage in the litigation, and the whole purpose of the Rule 26 discovery is to be open and honest in the discovery responses. When a client is asked to produce documents on our end, we gather the documents, we sort through them, we assess whether they're relevant and responsive to the question, and then we turn them over. In the context of the document requests and the court's order specifically requiring documents to be provided, Mr. Brule sends us spreadsheets, essentially.
I'm going to get to that.
Okay.
You're talking about the vestige?
Yeah,
spreadsheet?
right.
I want you to read me question number 1 again.
Okay. Please list and or describe as specifically as possible all medical ailments, conditions decedent was diagnosed with or believed to suffer from during the last year of decedent's life, including decedent's last illness and cause of death.
Okay. So why wasn't that answered?
Your Honor, I do believe we listed a bunch of things that he had.
Doesn't the answer start off, you have all his medical records, so you know?
Well, but he does. They have all the medical records.
Okay.
Yes.
But that's the answer you gave, right?
Well, that's the best answer.
Well, that's not the best answer. She either knows of conditions and diagnoses, or she doesn't know of conditions or diagnoses.
Well, she went with him to the doctor, but there's medicine. She knew he had a quadruple bypass. He had some other medical issues, which I've listed in these things. She
Read that question again.
Please list and or describe as specifically as possible all medical ailments, conditions a decedent was diagnosed with or believed to suffer from during the last year of decedent's life, including decedent's last illness and cause of death. And Your Honor, if I may, I mean, she mentions in her own text message Alzheimer's.
Okay. Was he diagnosed with Alzheimer's?
not that I'm aware of.
Okay. but she represented that he had Alzheimer's.
I think there's a message when she went, there may be something on Alzheimer's, she said, I don't know. I couldn't find it on her phone. I think counsel produced the text.
See, the answers to discovery are the answers of your client.
Yes.
And I understand you're assisting your client in providing the answers. That's kind of your job, okay? But the answers need to be given. It's a relevant question in light of the fact that they have text messages from Ruth, the daughter, that allude to these things, that not allude, state these things, from your client to Ruth, the daughter, right? Okay. So what's wrong with that question? Is there something wrong with that question as far as under Rule 26?
Your Honor, they have more medical, records.
I know what they have.
Okay.
I know what they have.
And she described she went through all the medicines he
My
takes?
question is there something out of bounds with that question?
No.
Okay. Then why doesn't she answer it? Why doesn't she answer it fully?
Well, Frank took care of a lot of his own medical needs. She doesn't know everything.
She knows in her mind that he had Alzheimer's, or she communicated that to Ruth, the daughter, right?
Or she was spouting off because she was upset about something.
Then she should answer then she should answer the question fully. Okay? See, you know what, I see in the complaint that the house in Florida sold for what, $1,020,000?
About that, yes.
Okay. It seems like Mr. Novak had a lot of money, and there's a lot of money out there. Okay. In this case, since this case management order went out and was filed on May 10th, it seems like there's been a lot of money sucked up in the discovery process unnecessarily. Because I think there are a half dozen separate orders that have been issued addressing discovery. I've never had in 7 years, 10 months, and 23 days, that many orders issued on discovery.
Okay.
Never. And it's completely unnecessary. Okay. And so far, we've got 2 examples, question 6 and question 1, where a lot of time of a lot of expensive lawyers were sucked up dealing with issues that should have been easy answers, easy questions, easy answer. And when lawyers are sucking up a lot of time on discovery issues unnecessarily, parties are paying money
That's true.
unnecessarily. Okay? So, and this answer was provided November 14, Mr. Freed?
Yes, Your Honor.
Okay. So that's 2 that she's ignored. She's ignoring me. She's ignoring orders because she doesn't want to comply with the orders.
That's not her intention, Your Honor.
Well, the road to hell is paved with good intentions? Is that what that saying is?
Yeah, it
Okay,
is.
I don't care what intentions are. I care about the results, okay? Because the intentions don't matter. The order says what the order says, and the obligation of the party is to comply with what the order says,
Yes.
okay? And that hasn't happened, Okay, and that's why you're here at 7:30 on November 23rd. Okay?
When I started this case, Your Honor, you know, I went through all the questions and stuff. She did not have text messages. She's cleaned her phone for years. She didn't have anything. When we did forensics was a substantial.
I'm getting to the forensics.
Okay, okay.
I'm getting there.
Okay.
Okay, I'm getting there. Mr. Freed, I think you also indicated, was it question 13, interrogatory 13?
I believe so, Your Honor.
Okay.
May I, before I get to 13, get to 4?
The only reason I asked you about 13 is because you addressed that after 6.
Oh, yeah, sure.
All right, so
If I might backtrack to number 4.
Okay.
You know, instances of cognitive decline and failed memory are some of the early signs of dementia. And so we ask a question, please state whether you were ever present during any instances where the decedent forgot having provided financial assets and/or financial support to one or more persons. A component of a capacity, I believe, question. And we have text messages where, and your father has no recollection.
Are these text messages between Laura and Ruth?
They are, Your Honor.
Ruth, the daughter.
Yes, Your Honor. And your father has no recollection of all the money he's paid Danny, and especially the last thing with Lana and propping them up in that condo a couple of years. And there's numerous text messages where she complains about her father's memory, or her husband's memory. And that, so in response to number 4, the question again, please state whether you were ever present during any instances where the decedent forgot having provided financial assets and/or financial support to one or more persons. Objection to vagueness of question. Nothing specific that I recall. It was difficult to keep up with the adult children's financial requests for the ones I was aware of. Another evasive question, answer.
Okay. So it seems to me whether you were present when these incidents occurred is either no, I wasn't, or yes, I was.
Your Honor, everything that counsel has spoken of is there's a few text messages that were between Laura and Ruth. I looked at them again last night. We didn't have them in the beginning of the case, and I think they were, a lot of those happened when she was away for 2 days and having an argument or disagreement with Frank. And she was, she said that one thing about Danny that he forgot, but as to competence, as to what's going on.
Wait. I'm addressing her response to interrogatory number 4, okay? And so it doesn't matter to me whether when she became aware or remembered when text messages were sent about Danny or anybody else. The question is simply whether she was present when these events occurred, or these statements occurred, or these acts occurred. And she either was present or she wasn't present.
I went through these with her. There's text messages and stuff that I have now seen that counsel's produced some of them.
Okay, but wait, see, her obligation is to answer the questions.
Yes, sir.
Her obligation is not to answer the questions when she gets other information from the plaintiff, okay? You do your discovery, he does his discovery, okay? Independent of that, she either has knowledge of that, she either was present when those things occurred, or she wasn't present when those things occurred. That's not a complicated question, right?
She didn't remember any of that stuff.
Then why didn't she say, I do not recall ever being present when Frank said anything about the financial situation, whatever the question?
She didn't recall that, and she didn't recall it, but there is some text messages.
But why isn't that her answer?
Referring to the text messages?
Referring to whether she was present when that happened. Either yes, I was, no, I wasn't, or I don't recall ever having been present. It's three possible responses.
She did not recall when I,
That's fine.
okay.
If that's what it was, that's what it was. Why isn't that the answer on November 14th, if that's what the answer is?
In terms of the word being present, whether she was present when he did it and stuff, I don't know sitting here today, but she's told me she didn't recall doing that stuff. There's just the text messages, so I can go back and change the do not recall, but she said nothing specific. It was difficult. This was a busy period in her life, and there was children coming in and out. They were it's the Christmas and stuff. And
That's fine.
Yeah.
I mean, that's fine, except the question is the question,
yes,
and the answer is the answer.
yes.
And she won't give the answer. Okay, this is the third time now, 3 for 3, where she hasn't given an answer, or she's given a non-answer. It's not responsive to the question. This is after several orders, okay, to comply with discovery. So my conclusion is, so far, in the last 45 minutes, she doesn't want to comply with this stuff. That's my conclusion so far.
Well, it's not that she doesn't want to comply, Your Honor. I think that everything that I've heard right now has been from text messages between Ruth and her.
I don't care. The text messages to me are irrelevant.
Okay.
Okay. The only thing relevant is the question that was asked in interrogatories and the answer that was given. That's all I care about.
Okay.
Okay. Now, typically, lawyers don't ask questions that have nothing to do with the case. Okay. Mr. Sebastiano seems to me so far in the 3 questions I've heard asked the questions because there was relevance to it based on information he had obtained independently, okay? But regardless of that, the text messages for the purposes of what we're discussing here are irrelevant. The questions and answers are the only thing that are relevant. Mr. Freed, do you have other you wish to address?
I'm sad to say yes. And I could go through all of these. The reality is, number 5 is demonstrates really the twisting of the answer to essentially degrade the decedent's children. So in relation to the question which we just covered, number 4, we say in number 5, if your answer to the preceding interrogatory is in the affirmative, please describe all such instances. In so doing, please state the recipient of such assets and or support, the date such assets and or support were provided, and when decedent forgot having provided such assets and support. Frank Novak handled the financial affairs. He also worked with the tax professionals. The adult children would be the best persons to answer all monies requested and received from Frank Novak over the years. More recently, there was a fairly substantial request for funds that was requested from one of the adult children that had her house burned down. From the defendant's own, and she's not here today on this issue, from the defendant's own words in her text messages, she's describing these kinds of things, these forgetfulnesses associated with giving money to children. It is purposely vaguely, as we've seen in the other correspondence, purposely vague. Your Honor?
Your Honor, excuse me, this is Mrs.
All right,
Novak.
so if the answer to 4, if the true answer to 4, as you indicated, Mr. Brule, is that she did not recall, then why does she go on to cite instances in 5 that relate to the proper answer for 4?
Your Honor, thank you. Frank Novak handled all the financial affairs. Laura Novak did not handle any of the accounts, any of the money to the children. All her information is secondhand. She's aware that there was requests for money, and the actual amounts of money, Mrs. Novak doesn't know. She's not hunting through Frank Novak's financial records as to what he's paid over the years, but he did all that. Mrs. Laura Novak didn't pay any money to any kids. She's familiar that there was problems with kids because one of them had a house burned down and was asking for money, and it created a lot of consternation within the household. But she doesn't have personal knowledge of each money. The best person that knows that was either Frank or each of the kids. She doesn't know. He handled all the financials.
Okay, Mr. Freed, read that question and answer again, please.
If your answer to the preceding interrogatory is in the affirmative, please describe all such instances. In so doing, please state the recipient of such assets and/or support, the date such assets and/or support were provided, and the decedent forgot having provided such assets and/or support. In the answer, Frank Novak handled the financial affairs. He also worked with the tax professionals. The adult children would be the best persons to answer all monies requested and received from Frank Novak over the years. More recently, there was a fairly substantial request for funds that was requested from one of the adult children that had her house burned down.
All right, so if the answer to 4 is I don't recall, then there should be no answer to 5, right? Because it was based on an affirmative answer to 4, right?
Yes.
Okay. So, Ms. Novak, while you were absent, there have been, this is the 4th example of an interrogatory that was not answered. And you'll have to go over that with your counsel, but the discovery to this point has been a huge waste of time and money from the standpoint that the questions are simple and the answers so far, while you were not present, were not given. And the answers to questions need to be given. Whether you like the answers or don't want to give up the information is irrelevant. If a question is answered, if a question is asked, an answer needs to be given unless there's an objection and a sustaining of that objection. In this case, there have been overruling of objections, and the answers need to be given. I don't care if the two sides hate each other. All right, there's a dispute. The dispute has to be resolved here, and there has to be a cooperation and discovery in order to conclude the case. If there's not a cooperation and discovery, henceforth, there will be financial sanctions that will be issued. Now, it seems to me that I shouldn't have to have this type of hearing in light of the orders that I've already issued in order to emphasize that. But here we are. Mr. Freed, any other?
Excuse me, Your Honor. Okay. Number 18, Your Honor. If I might.
Go ahead.
And I'm trying not to be picayune about some of the answers and questions. So I'm skipping to 18. Please describe all instances when you communicated with any real estate agent, real estate broker, and/or other person or entity, excluding the decedent, regarding the sale of the Amberwood home and/or the proceeds therefrom. As used in this interrogatory, real estate broker, and other person or entity shall specifically include, but is not limited to, John Woods Properties, Comey, Conrad, Durant, PA, and/or Woods, Weidemer, McKetty, Rudnick, P., as well as any other respective employees, agents, members, partners, officers, directors, shareholders, and/or representatives. So in response, it's written, this is asking who I talked to over 1 year ago. Generally speaking, my communications related to cleaning and readying the house for sale. Supplemental. Note, I have not reviewed responses, files from Florida realtors, brokers, agents in excess of 500 pages. There was a communication to Laura Novak from the Florida personnel inquiring who Ruth Novak was and that she called to check on the sale. The vast majority of the dealings on the Florida property were handled by Frank Novak, as the file should reflect. The issue really being, who did she talk to when? She has phone records, she has all the communications that she should be having and recollections. This is not that long ago. And we believe that her answer is not fully incomplete.
Mr. Brew?
Your Honor, I think we have reached in the valleys of the picayune. Mr. Novak handled the entire Naples sale. He dealt with all the realtors. They have subpoenaed records from 2 firms in Florida. They have all that stuff. If anything happened from Laura Novak, it would be in there. She didn't handle that stuff. She did some of the stuff for cleaning the house and things. She may have talked to the realtor a couple times, but Frank...
Which realtor?
Jerry DiGeronimo, I think he's the realtor that handled the Naples sale.
Giacomo.
But Frank handled the whole sale. He did the closing, he did all the documents, the financials, the loans. He handled all that with attorneys down there. Laura was pretty much out of that whole situation. So she's not evading anything there.
Okay, read me the first part of that question again.
Yes, Your Honor.
And what number was this?
18.
18.
Read me the first part of it.
Please describe all instances when you communicated with any real estate agent, real estate broker, and/or other person or entity regarding the sale of the Amberwood home and/or the proceeds therefrom.
Okay. Did she provide in that answer Jerry DiGeronimo?
Yes, I think she may have talked to...
No, did she provide that in the answer?
No, Your Honor, I don't interpret it.
Laura never talked to Jerry.
Okay, well, I only asked that because you said that she talked to Jerry.
Well, that was my impression. There may have been one call.
Okay.
She didn't talk to Jerry.
So there seems to be, so far in the last hour, 2 apparent problems with regard to these plaintiffs' interrogatories. The first is that your client doesn't want to answer them and doesn't answer them, okay? And the examples we've seen gives a narrative that don't respond to the question and or evade the question. And the second, it seems like she's doing that with your approval. That's the way it appears to me.
Your Honor, we're trying to fully answer the question.
No, you're not. No, it's very apparent to me that you're trying to not answer the question. Because, the reason I say you're trying to not answer the questions is because you're not answering the questions. The first two were simple yes or no answers.
But
So those two things have become apparent to me.
okay.
So why is that? Now, before you answer that question, okay, how many fact depositions have been taken?
Just one.
Okay, and whose deposition was that?
Mrs. Novak senior.
Okay. Whose depositions do you intend to take?
Well, Your Honor, we tend to take the defendant. We'll probably take the real estate people in Florida. A few other people, if we can get all the text messages so we can assess who else Laura Novak was talking to about these things.
Okay. So the fact deposition deadline is December 16th.
And from my perspective, it's probably not possible that we'll be able, because we don't even have the documents.
Okay. Okay. Am I to presume that you're going to ask for an extension of that date?
Your Honor, we're going to ask for an extension, absolutely. I mean, I suppose I could corral all our Reminger attorneys to go out all over the place to take depositions, but we're at a disadvantage without all the documents.
Okay. Are you going to oppose the extension of that date?
No, Your Honor.
Okay, so how long am I going to have to extend that date?
I asked for depositions for all 6 of the adult children. I haven't heard back. I also want to take the realtors in Florida's deposition. We both agree on that.
Okay. So my point is, how does the plaintiff conduct a deposition in a competent manner if he can't get answers to questions that have been outstanding for a long, long time? How does he do that? And you said that you've answered the questions, okay? And I've concluded that you haven't answered the questions. So how is he to do that?
There's been, in my view, Your Honor, there's been more discovery in this case than I've seen in a lot of cases over a long time. There's been 5,000 pages of subpoenas.
It doesn't matter to me.
Okay.
The only thing that matters to me is whether any documents produced and answers given were germane to the questions asked or the requests made. That's the only thing that matters. So I don't care if it's 5 pages or 50,000 pages. If they're not germane to the request, and if the answers are not germane to what's asked, it doesn't matter what you give. So, are there more interrogatories?
Your Honor, that concludes the major concerns
Okay.
with the interrogatories.
All right, now, Mr. Brule, tell me your issues with discovery from the plaintiff.
Yes. I think the case started off with allegations, and I said this before, and Your Honor said, it doesn't have to be verified, but on competence, we had a good deposition with Ruth Novak Sr., and she denied he was not competent, and that was
Okay.
used.
All right, but you took her deposition.
Yeah, so
That
was one.
What impediments to discovery have the plaintiffs provided to you?
Well, I think what it did, I think it opened the door for them to, to say that, to get medical records and stuff that they weren't entitled to.
Well, they were entitled to them, right?
Okay.
Didn't I address the medical
Yeah.
records? How did I address the medical records?
You released them.
Okay, so don't tell me they're not entitled to it when I concluded. See, you're fighting battles that are over because you objected to the medical records.
Yes, sir.
I determined they were relevant, and I ordered them to be produced.
Okay.
Okay? So that battle's over. So don't fight battles that are over. What impediments have the plaintiffs put up that have prevented you from getting discovery that you're entitled to,
We've asked for deposition dates for all the 6 children, haven't heard anything.
okay?
When we did forensics, we asked counsel if they wanted any of them, because so many of them were non-responsive. There was thousands of them. I had the emails, and I just asked counsel to choose, so I then sent all these things that were non-responsive.
So the reason Vestige got involved was what? Explain that to me, Mr. Brewer.
Vestige was involved because, in my view, plaintiff was not happy because the information that was produced from Laura's iPhone, and there was problems with the computer, and then there was Frank's computer, so I'll go through them each. Laura's iPhone had very little information on it. I personally looked at it, and she's OCD perhaps, but she deletes and cleans things to try to preserve her phone. And so there was none of the text message and stuff were available when we started the case. They came from defendant. And so she has an old computer that didn't work. I personally looked at it. It didn't work when I went to her house. I took it back to my office. I got it operational. And that's what we gave to Vestige in order to fully comply with the judge's answer. We got forensics. We worked really hard with Vestige. So I had them go to her house, image her phone. I had her computer in my office. I FedExed it to them, and we had them image Frank's, or they imaged or took Frank's old computer, and he had 7 emails. We found more emails than they requested, and we gave all those. We had the search terms cover all those emails, and a lot of them were non-responsive and old, and that was the list. That's part of the list that I asked them if they really want those particular emails to go through. So we worked very, very hard with Vestige to get all that stuff on a timely basis for the court. In an effort to show the court, we're not hiding anything. We opened up all the electronic files. And the only thing that's really sitting here, I think is a bone of contention, are text messages that Laura had with Ruth, I think when she was at Bass Lake taking 2 days because of a disagreement for children.
But it doesn't really matter.
Right.
The text messages are the text messages, and whether they come in at trial is a separate matter. We're in discovery, right?
Yes.
So, besides the depositions of the adult children and Vestige, what other issues, discovery-wise, do you have with the plaintiff?
Well, I think I'll have more once I get through the children.
Well, but I'm asking you right now, what have they impeded you in any way?
We need emails and texts between all the children back and forth we've asked for. And we want to get the same things off their phones and computers to see what they're saying about their father. They were with their father not often.
But did you ask for that information through production of documents or interrogatories that they have refused to give you?
No, as to, I haven't done like Ruth Jr.'s deposition yet. So we asked, I gave a form to counsel. What I would like to have is the emails and text, because right now I have a one-sided case going on. We get the emails and text.
Did they refuse to give you?
Well, they haven't given them to me yet. They're not.
And so you've got an outstanding, production of documents request?
There's two subpoena duces taken that I sent to Mr. Sebastiano, and I asked that they be done. But, we're trying to hold it in advance till we have this hearing. And then I also wanted to have emails and texts from Ruth Sr. When we had a deposition with Ruth Sr., I asked her to bring all documents she relied on. She brought 0. Another problem we had is when we took Carrie, which was one of the daughter's depositions, apparently Mr. Sebastiano called the counsel that was handling Carrie's deposition and instructed him or told him not to answer a lot of questions. So I took a deposition in which I was thwarted from asking questions that led to the problem.
Okay, is this before me in any way, by way of motion or anything, or?
Excuse me?
Me?
I haven't written motions to compel and to do.
Okay, well, do you want to respond to what Mr. Brewer has brought up?
I really don't know what he's talking about. I've seen emails where we've requested and tried to work out dates for depositions. These text messages that I've been exhibiting for the court for purposes of addressing the issues of the interrogatories were part of our production. When we do a production, we bait stamp it and we send it to the opposing counsel. So they have these documents. He's acknowledged he has these documents. He's also said that his client has deleted text messages. When did he? We can't get an answer when things were deleted. From what device?
Okay, so let's get to Vestige. What were you provided that Vestige produced?
Your Honor, may I approach the bench just to show you an example of what we've received, rather than any documents that might be responsive to our questions? Like, for instance, I'm handing you something that's meaningless to me as I look at it. I couldn't decipher that. And asking us if we want to, which of those documents we want. And there's another document that's like 400 pages long. It's almost as if the plaintiff is used to do their job and going through the documents to answer and provide documents that are responsive to our questions.
Your Honor, if I may, we use the search terms essentially that they asked for. That's what came out of it. We want to show them the universe of what came so they could choose what they wanted to have.
Okay, so if they want to choose MAC 00000003, which relates to the file name 9022-711-6-469-A953-E764-6D-F88F48.PNG with the file extension PNG. What is that document?
My understanding is I have access to all those documents. So let me
What is that document?
that particular document? Yeah. That's probably an email or a picture.
Do you know that for sure?
No, you asked me what it probably was. Without looking at what's on.
If you don't know what it is, how do they know what it is?
Can I see that one?
Yeah, it's the third one down. MAC, bunch of zeros and 3.
I think there was more to this. This is just part of it.
I understand that, but what is it? Do you know what it is?
Those are all files that were downloaded by
Okay.
Vestige.
And so you sent this to Mr. Sebastiano and said, which ones of these do you want?
I sent more than that.
I know, you sent this, right? You at least sent this.
If he's got it, I probably did send
Okay,
it, but I sent a lot more than that.
I understand, you just said that, okay, but you sent this to him and said, which ones do you want? Go through these and tell me which ones you want, right?
Well, there was 3 devices.
Listen, my question, I'm trying to get a handle on what Vestige did, okay? And MAC 03 and a bunch of other MACs were sent to Andrew, right? And you said to him, tell me which ones you want, right?
Yes, I do remember the first one on the phone showed exact ones that were sent from Laura. That
Okay.
one.
It doesn't matter, okay? You are asking Mr. Sebastiano to tell you, based on this list, which ones of these things he wants.
Well, what I did, Your Honor,
I can't get an answer out of you, Mr. Gould. I have a very simple question,
Yes.
and every time I ask you a question, I get an answer that doesn't relate to my question, okay? Did you send at least this document to Mr. Sebastiano and ask him which of these he wanted,
the answer is probably yes,
okay?
because he wouldn't have it otherwise.
All right, so how is he supposed to tell what MAC 03 is?
Probably can't from that one, if that's all there was with it. I'd have to look. But I sent an email to him. I said, which ones do you want? I started with Laura's.
Okay,
And,
isn't your obligation to send him anything that's relevant? with regard to the production of documents and/or interrogatories?
I just sent all of them to them.
Okay. Isn't that your obligation?
Yes, although there's a lot of things that came out that were nowhere near, I think, what they're asking for.
Okay, how do you know that? Because you reviewed them.
I looked at a few of them.
Okay, so did you pull out what's relevant to this case?
No,
Why not?
because there's thousands of them through Frank's computer.
That's the way it is, right? And there may be some relevance, there may be no relevance. It may be all relevance.
I'll send them all.
Okay, but this is your obligation.
Well, Your Honor, I tried it. What I tried to do, Mr. Sebastiano, I said, I've got this now. Tell me what you want.
He can't possibly tell what he wants from this.
But on the first one, he could have said something, he could have said this, and by the way, I can't review that, so if you have something better.
You know he can't review that. You know, without giving it a second thought, that he has no idea what MAC 03 is. You know that, right?
Well, I know you can't do that. I know he can't do that.
Then why do you ask him to identify which ones of these he wants?
I'm not sure that was the whole thing that was sent, Your Honor. But I did ask him, I said, tell me what you want to have, and like for the first one, start there, and we'll start producing them all, if he wants them. There's thousands of them. I'll send the whole list.
The list of what? What MAC 003 actually is?
No, I have the actual email that associates with, those were the files they found.
Right, I understand that.
So so on the thing Dusty showed me, it was very odd, that they had a link on the file, and the links don't work with all the computers. So I had to download those separately, and I have 3 files. I've got a file from Laura's, I've got a file from Laura's computer, and I got a thing from Frank's. I've got files, there's thousands of them.
Okay. Mr. Freed?
Your Honor, the order required production of the documents. He's already acknowledged now that he's downloaded them and chose to simply give us lists and say, pick what you want, without giving us the opportunity and without him doing his due diligence and identifying in relation to the request for production of documents that we issued. He knows what we want because we issued requests for production of documents. And so he's asking us to cherry pick from lists what we may or may not want. Some of the lists he provided, he also did redactions without identifying what the redactions were about. Produced no...
Well, what other lists are there besides this list right here?
This list here, Your Honor, is one of the lists that was created, and then there's another one that I couldn't bring in because it was like 500 pages long. But I got a link.
Any of the redacted ones are just me.
Why are you redacting?
Just between me and Laura, their attorney-client.
All right. Do you indicate that they're attorney-client, or did you indicate that to Mr. Sebastiano? This is so small that I can't read this with my glasses on.
I know, they're huge files.
Okay.
But I try to get it, they can always, not true, Your Honor, but they can always expand on the computer. I have the same problem when I receive it.
To demonstrate the bad faith, I mean, it's in that list, so there's not even an attempt to provide a list of relevant things that we've requested. In that list are clearly what look like advertisements that come in your emails or text messages.
That's because the thing asked for anything to Laura, anything to Frank, and so the universe of what they asked for picked up.
Well,
what was in there.
let's assume that you didn't have to go to Vestige to recover this stuff, okay? You would have had a bunch of emails or whatever, information on these devices that may have been relevant to a request for production of documents, right?
Yes.
Okay. And had you not had to go to Vestige, you would have gone through the emails and properly responded to the request for production of documents, right?
I did that for her iPhone, and I did that for the computer. I went through those devices.
Okay, so you've provided those documents to Mr. Sebastiano?
What she had on those, I did.
Okay.
I'm pretty sure I did.
Do you have any knowledge of that, Mr. Freed?
Your Honor, I'm not going to make a representation.
Okay.
There's so much,
Right. But the point of what I'm talking about is, had you not had to go to Vestige, you would have reviewed emails or whatever documents exist on these devices, determine what was responsive, and sent that to the other party, right?
And I did review them, and there was nothing responsive. They complained, so we went to Vestige to try to get things because they thought things were, not there.
Okay, and Vestige recovered a bunch of stuff, right?
They recovered everything that was
Okay,
search terms.
so isn't your obligation the same, to go through those documents and to produce what is responsive to the request for production?
I was just gonna, if I was going to go, I was gonna just produce everything and not cherry pick, so they say I cherry pick something, because of the search terms being so broad.
Okay, but your obligation is to go through these documents, determine what's responsive, and give those to the other side, right?
And I spent considerable time going through them, and I saw a lot of them were not responsive, that's
Okay.
what.
And then I take it that you determined that some of them were responsive.
Well, I thought we'd start with that
Okay,
list.
I don't care where you start.
Right.
You've got information from Vestige,
Right.
and you need to go through the information from Vestige and determine if they're responsive, and then give them over.
Your Honor, I went through a lot of them, and I didn't see anything that was responsive to what they were looking for. That's why I sent, tell me what you want, instead of me just sending them wholesale.
Okay. But once again, going back to 10 minutes ago, nobody knows what MAC 03 is. You don't know it, they don't
That's the
know it.
whole thing.
Okay.
Double check.
So I don't know why you would give a list like that to Mr. Sebastiano and tell him, pick what you need.
I think there was more to it than that, but I'll check.
That's the problem, okay? That's the problem, that's why we're sitting here.
I also, in giving information to Vestige, he neglected some of the things that are relevant, including the timeframes that we were asking for. In other words, the sale of this home starts in September, I think, of 2020. He specifically asked Vestige to search 2021 to 2022. Things like Alzheimer's and forgetfulness, certain kinds of questions that we would have clearly wanted because it's related to the issue of capacity or undue influence, not provided, not searched. So he selectively chose search terms that would not fall within the parameters of what we were looking for or be particularly relevant. So he didn't fully do the search terms. We know that there are additional email addresses used by the decedent. We know by the defendant. We know she has social media. None of that was searched or provided. We're just at a complete loss with regard to the circumstances of give us the production that is related to the questions that we asked, relevant to the questions that we asked, so that we can do our job and represent our clients in the pursuit of this case. We've spent, I don't have the bills in front of me, I would not be surprised to say tens of thousands of dollars dealing with this back and forth, starting with the blocking of discovery attempts when they filed a motion to dismiss. And we're here again after, I think, 3 or 4 court orders previously. It's very frustrating as an attorney who tries to talk to their clients about the process of court and how important it is to comply with the court orders, to comply with the discovery requirements. It's just frustrating, Your Honor, and I appreciate you having us here.
All right, I'm going to take about a 10-minute break.
All right.
And the plaintiff's position is they requested certain search terms that were not utilized by Vestige. Is that correct?
Your Honor, with the caveat, we wanted responses to our request for production of documents, and we aided them along with additional search terms that might help get there.
All right, did you provide search terms
We did.
to Mr. Brule that were not the subject of the search
I believe so, yes.
that go along with that list?
One of them, for instance, Alzheimer's, forgetfulness.
Is that correct, Mr. Brule?
You know, we put medical and everything to capture that. We put in terms medical or just,
All right,
you know, those.
there were, I think on November 10th, certain words and or phrases that were requested by the plaintiff, correct?
Yes,
All right, were those provided to Vestige to search?
substantially, yes. I went through the.
Yes or no? Did you take that list that you got on November 10th, give it to Vestige and say, use these search terms?
I gave the search to Vestige, and then we went through the 3 devices. I said some of these are overlapped and stuff, and they cover what they were, so run it like this.
After the fact?
You know, we're working with Vestige, yes.
Okay, no, see, on November 10th, Mr. Sebastiano provided requested search terms for Vestige to utilize, correct?
Yes, it was a week after I asked for them.
Okay.
And we had already started.
Okay.
But yes,
So yes,
yes.
okay. And were those search terms given to Vestige to include in their search of the devices?
They got the letter, and we worked on the search terms, and the answer is yes, but not every single one was used.
Okay, so no.
For a couple of them, yes.
Okay. Why was that?
Because the other terms seemed to capture everything they were looking for.
Was that your conclusion or Vestige's conclusion?
In working with Vestige.
Okay, okay. All right, so now we've got, seems we have a fundamental distrust between the parties going on here, right? So in the normal course of things, it would be the respondent would have to go through all of these documents and determine which of these documents were responsive to a document request, right? Everybody agree on that?
Yes,
Yes.
Your Honor.
Okay.
Or to provide everything that was a search term.
Well, and here we get into the distrust, okay? Okay, the plaintiff doesn't trust you to do that, right? And your response is to give them everything, and they can wade through it, right?
I'm fine with that.
Okay. Well, that requires, and I don't know how many documents there are altogether, okay? And we don't have all the documents altogether because there are search terms that were eliminated, okay? So that could be tens of thousands of documents, 50 of which may be relevant to a response, right? And so your position is it's on them to wade through all those perhaps tens of thousands of documents and determine which ones are responsive to the
Not necessarily.
production. No? Then
That
what?
was the search terms that they asked for.
I know that.
And so I want to give them what they asked for.
Yes, and some of what they, and not give them some of what they asked for. Okay.
No, they can have them
So
all.
I guess where I'm headed on this thing is I'm probably going to appoint somebody to look through all these things, okay, which is going to cost money. But that's the only solution, okay? Because from your perspective, Mr. Brewer, you want to give them everything and have them go through it, okay? Which is impractical and not in the spirit of discovery, quite frankly.
Or I could sort them if Your Honor wanted.
And they don't trust you to do that.
I understand
Okay,
that.
so here we are, all right? So what is a relatively simple case, an issue of fact as to whether Mr. Novak was unduly influenced and or incompetent or whatever terms you want to use, whatever the cause of action may be, finally presented to a jury, has become a very complicated and expensive matter because the parties can't stand each other, okay? So the likelihood is I'm going to appoint somebody that's going to go through all this, okay? And that will trigger the final response to the production of documents. In the meantime, I don't imagine that the plaintiff is going to be in a position to take the deposition of the defendant without full paper discovery. And the defense may not be in a position to take the deposition of the Novak family without those documents. Am I correct in that assertion?
Yes, Your Honor.
Yes, Your Honor.
Okay. So I have an idea who I'm going to appoint to do this, and then I'm going to apportion the cost of that exercise in the way that I think it should be apportioned. In the meantime, I want these interrogatories answered. I want responses to the interrogatories that are related to the question that is posed, okay? There should be no outstanding objections on the question because they've been ruled on, correct?
Most of them, I think, Your Honor.
Are there some that haven't?
I don't think we went through them all individually, no.
Okay.
Well, I'll go back through all the interrogatories
Okay.
based on
And,
those text messages.
and just so everybody understands, there should not be objections raised to interrogatories that have already been ruled on since they've already been ruled on, and that's where I'm at, right?
I'll take those off.
Okay? So, and I want this done by December 2nd. I want proper answers to interrogatories by December 2nd, and I want a copy of those proper answers to interrogatories emailed to me so I can look at them and I can compare them to everything that's been done.
Okay.
So when did I say this case was filed? December 23 of last year. And the best case scenario is we're looking at a trial on January 8th of 24 on something that is not a complicated factual issue. Is there anything else from your end, Mr. Freed?
No, thank you, Your Honor.
Mr. Brule?
If there's other production that the plaintiff has that hasn't been produced to us, because we haven't seen all the emails and texts of the family, we can't answer everything, because they may have things that we don't have, I will do what
Okay, well,
I have.
If you've got outstanding interrogatories that haven't been complied with, haven't been answered sufficiently in your view, such as objections that you don't think are warranted in their refusal to answer, or if you have requested documents through a production of document requests that haven't been complied with, then file your motion to compel, motion for sanctions, and we're not going to screw around with this case anymore, okay? I've reached my limit on having to issue orders that I shouldn't have to issue, okay? I've reached my limit. So now, from now on, if I don't get compliance, if you guys don't get compliance, forget me, okay? I'm just sitting here as the referee. But if you guys aren't going to comply with each other, then it's going to start costing you, your clients, and/or you money in the way of sanctions, okay? Because I'm just telling you, this is your only warning. We're going to quit screwing around with this case. Got it?
Got it?
All right. If you want to use that smaller courtroom for your thing, you can do that.
Thank you, Your Honor, I really appreciate it.
Thank you, Your Honor.
Can you just take a minute?
counsel John Fatika. In case number 21 CR 1199, the defendant is indicted on 2 counts of vandalism as a felony of the 5th degree. In case number 21 CR 1343, the defendant was indicted in 1 count of aggravated possession of drugs, a felony of the 5th degree with the forfeiture specification for contraband and instrumentalities. And in case number 22 CR 502, the defendant was indicted with 1 count of failure to appear, a felony of the 4th degree. We are here today for the pretrial in all 3 cases.
Are there offers?
Your Honor, the offer in case number 21 CR 1199 is a plea to 1 count of vandalism. They are charged in the alternative. In 21 CR 1343, plea to the indictment, and in 22 CR 502, also plea to the indictment.
All right. Mr. Fatika?
Good morning, Your Honor. We're not in a position to accept the offer right now. We'd like to mull it over, go over some more specifics. I'm having the discovery in the older 2 cases sent over to the jail today. But we'd ask for a change of plea date and a jury trial date.
All right, the 1199 case will be set for a jury trial January 9th. The 21-1343 is set January 23rd. The 22-502 is set February 6th. So if they are going to be resolved, then I'll leave it, since it's plea to the charges, essentially, it's each indictment. There's no deadline for any offers, so if he's going to plead, then I'll leave it to you, Mr. Fatika, to get a hold of Maria and schedule something. All right?
Thank you.
Anything else?
No, Your Honor.
Okay.
I'll be in touch.
You seated, Ms. Mulligan?
Your Honor, we're hearing the matter of the State of Ohio versus Devontae Eason. This is case number 22 CR 1144. Mr. Eason is present in court. He is accompanied by his attorney, Mr. Troy Murphy. We are gathered here this morning on the defendant's motion to reduce bond. The state has filed a response to that, and it is the state's position that the defendant ought to remain in the jail on a no bond condition, on bond set previously in the municipal court. Be no bond.
We're also hearing a pretrial too, correct?
That's my understanding, Your Honor.
Okay. Is there an offer?
We would ask for a plea to the indictment, Your Honor.
Okay. Mr. Murphy?
Your Honor, that's correct. We are here on both a pretrial and a motion for bond reconsideration. Obviously, I just heard the offer from my client. I've not had an opportunity to speak with him. I would anticipate that he would not accept that at this point, as we still have to go through discovery and things of that nature.
All right. What do you want to say with regard to your motion?
Your Honor, thank you. Your Honor, I have received a 2.5 to 3 page letter from Mr. Eason's primary care provider, who is a certified nurse practitioner. My fingers don't want to work. Sorry, Judge. Consuela Albright. Your Honor, if I may approach to provide a copy. I provided a copy to Madam Prosecutor. Thank you.
Your Honor, we just ask that for purposes of maintenance of this document in the file, that it be
Kept in the file under seal, given that it contains personal medical information of Mr. Eason.
Okay.
Your Honor, in relation to this, and I'll try to, obviously the letter is somewhat self-explanatory, but to highlight some of the primary things. Your Honor, Mr. Eason suffers from sickle cell. He's currently an adult patient in the Seidman Cancer Center at University Hospitals. He suffers from sickle cell disease, which is a condition that causes red blood cells to change shape when exposed to low oxygen conditions. This, in essence, causes blockages in the blood cells, causing pain and organ damage. Your Honor, there's, to demonstrate the effects of the condition, it indicates in the letter that typical blood cells, red blood cells, have lifespans of approximately 120 days, whereas Mr. Eason's blood cells only have a lifespan of about 10 to 20 days. He also suffers from chronic anemia, from low hemoglobin, takes medicine called hydroxyurea to remain well and prevent long-term effects of the sickling. Your Honor, he's being treated for a number of other chronic medical conditions secondary to sickle cell disease, including hepatic cirrhosis, portal vein hypertension, cardiomegaly, borderline hypoxia at rest with nocturnal hypoxia, requiring him to wear 2 liters of oxygen for sleep, hypertension, hepatic cholelithiasis, and priapism. Your Honor, he requires regular follow-up for his sickle cell disease with Ms. Albright's office, but he also has several other specialists for his secondary medical conditions. Your Honor, the basis of this motion is, as the letter goes on, Mr. Eason is required to have 2 liters of oxygen while he sleeps at night. The letter also delineates that he's required to have oxygen on demand for purposes of when it's needed during the day. He's also required, I don't want to say required, he's also prescribed oxycodone. And we understand the jail's position that they don't allow that to be given. The oxycodone is for the pain. If you continue to read the letter, Your Honor, it indicates that he will suffer from severe pain
from his sickle cell disease. He also is at risk for serious injury or death, including sudden cardiac death. And it is the position of Ms. Albright that Mr. Eason be allowed to, I guess in essence, be released under some form of house arrest so that he has access to his regular quality medical care. She indicates at the bottom of page 1, Your Honor, that he does not have oxygen. They've sent notices to the jail regarding the oxygen. It's my understanding, which is not contained in the letter, it's my understanding that the jail has indicated that Mr. Eason can arrange for his own oxygen. Obviously, due to incarceration, he's not able to do that. His mother and stepfather, who were here Friday and are supposed to be here today, I don't know the reason they're not. I've also, it's my understanding, tried to arrange that, and it's been very burdensome and unsuccessful at this point. Your Honor, it also indicates for the pain crisis, the jail offers him acetaminophen or ibuprofen because they don't administer oxycodone. But as you can see at the bottom of that first page, that indicates that the acetaminophen and ibuprofen actually worsen his liver function and could cause new or worsening gastric variances, which he is already at risk due to his hepatic cirrhosis. There is a note that they've had contact with the jail, and the jail will not prescribe or administer oxycodone for Mr. Eason. They do give, Your Honor, to be fair, they did give an alternative to house arrest on page 2. It says if he cannot be given house arrest, please consider the following care recommendations. The problem is, Your Honor, it still requires the oxycodone, and then for the medication portion of that recommendation, and then under the maintenance portion, it still says an oxygen concentrator with oxygen delivery supplies for nocturnal oxygen, meaning the 2 liters that he's prescribed at night, as well as oxygen delivery during the day as needed. Your Honor, his condition is so severe that even if he gets a fever, he's supposed to be referred to the emergency room, as it indicates at the bottom. Things as small as normal abdominal pain have to be immediately evaluated in the emergency room, because with his condition, unlike you or I, Your Honor, where abdominal pain, we have a little bit of time to figure out, is it severe or is it something I ate, for instance. Mr. Eason has to be immediately evaluated. Your Honor, I illustrate this. Last week, Mr. Eason had to be rushed to the hospital for abdominal pain. It was determined that he had gallstones, one of which, and this is why I went to law school, Judge, I'm not a medical guy, one of which was in a position to slip into a position that could have caused him need for emergency surgery. He was taken to Tri-Point. Unfortunately, Tri-Point doesn't have the ability to conduct that form of surgery. They took him to, in speaking with the Sheriff's Department, they took him, the next step would have been to take him to Ahuja. The problem is, when I spoke with Mr. Eason's medical providers, in order for him to have a surgery, he has to have what's called an exchange extraction. He can't have surgery without his blood being taken out and put back in because of his condition. The only location that can do that, according to the medical professionals, is the main campus of university hospitals. So the problem is that they take him to Tri-Point, being the closest emergency center, as required by law, I would presume, and then they say, okay, let's transfer you to Ahuja. Once he gets to Ahuja, Ahuja's going to say, we don't have that ability either.
Well, wouldn't they already know that?
I don't know, Your Honor.
I mean, they're all UH, right?
Correct, but I'm just saying if Tri-Point is a little, how do I say this? Tri-Point is a UH facility, but it's my understanding it's a newer UH facility. So for instance, the medical professionals that I spoke with that are his regular care physicians at main campus, they can access medical records from Ahuja, but they don't have the ability to access medical records.
They've been merged for over a year. What the hell are they doing?
I don't know. All I can do is portray the information that I've been provided.
No, it's just, okay.
Yeah, I was just advised they don't have the ability to look at their medical records at Tri-Point. Yeah, it goes on to obviously talk about a number of other factors regarding Mr. Eason.
we would just ask this honorable court, Your Honor, based on his inability, he's been detained for, I want to say approximately 39 or 40 days thus far, and despite being detained for almost 6 weeks, there's still been no oxygen provided to him. He's not able to get the pain medication that he needs. They offer alternatives, but it actually makes his condition worse. The pain is very difficult for him to endure without the medication. The priapism, Your Honor, also is an enlargement of the genital area, which also causes extreme pain to him, and as the letter indicates, it could lead to further complications if left untreated. So, Your Honor, we understand the gravity of what he's charged with. We're not saying that that doesn't exist. Obviously, we need to look at the evidence. We have some theories of defense, but I don't want the court to think we don't understand it's a felonious assault charge. We do. We're just saying, Your Honor, that in this case there seems to be some anomalies with Mr. Eason's condition, and despite being incarcerated for almost 6 weeks, and discussions and communication with the jail to try to get him what he needs as prescribed by his medical providers, they're either unwilling in the sense of the oxycodone, the only drug they have to administer makes his condition worse than the acetaminophen or ibuprofen, and they're unable to facilitate the oxygen, which the letter's clear could also be detrimental, possibly leading to sudden cardiac arrest. Your Honor, he's a 22-year-old male. He has no prior interaction with law enforcement or the courts. We would just ask this honorable court, for the sake of his health and well-being, to allow him to, we're not asking for a personal bond. We understand the court still would want to, if willing to entertain our request, keep good tabs on him. And I've spoken with his parents who were supposed to be here. They do have the financial means to pay for a monitor. Obviously, the only exception to the in-home would be for purposes of emergency or routine medical care. Thank you, Your Honor.
Can you tell me in the, say, month or 2 months preceding October 15th, what his normal treatment was at UH?
Your Honor, it's my understanding in the letter that he has regular treatment. Regular is somewhat, in my understanding, fluid, because sometimes he can go maybe 2 or 3 weeks. Sometimes, based on what they see, they need to see him right away. I don't know. We got over 200 pages of medical records, Your Honor. I will tell you, the dates on there were very fluid. Sometimes it was multiple times in a week. Sometimes it was 3 weeks. And that was over, I think, since January of 2019, if I'm not mistaken, was the records we got. We combed through them, Your Honor. It wasn't a whole lot to add. That's why we asked for the letter, to really delineate the specifics of the condition.
So his treatment is based on his day-to-day condition?
It is, yeah. And that's what necessitates, in his treatment is heavily relied on his ability to administer the oxycodone and the oxygen while at home to further maintain. Thank you, Your Honor.
Thank you. Ms. Mulligan?
Your Honor, I appreciate the health of the defendant is at issue here. However, I'm not prepared to argue against what Mr. Murphy has just said about his condition. But I do want to point out, and for the record, that the jail does have medical facilities, and they have the ability to take the defendant to the main campus of the University Hospital. I recognize this could be burdensome. I recognize it's complicated, but they are tasked with that responsibility when they're housing an inmate that has a serious medical condition. The serious medical condition did not prevent the defendant from engaging in extremely erratic, desperate, violent behavior that put the wife of his child and his child at risk. The defendant is properly held without bond when he poses a substantial risk of serious physical harm to someone, to his family, and to the community. This was a shooting that took place in a parking lot at 8 o'clock in the morning. And if you will, a desperate action that not only endangered the victim, there are two victims, the mother of his child and the child. The state is prepared to put on testimony. Detective Parmenter is here to describe to the court the nature and circumstances of the offense that's been charged, how the defendant, in an escalating domestic violence situation, hunted down the victim, laid in wait for her, disabled her car so that to try to prevent her from escaping, took a gun with him, held a loaded firearm just feet away from the car where the victim was sitting with the child in the back, and fired that gun as she was trying to flee on flattened tire. Shattered the windows. She managed to continue driving despite the disabled car. He chased her after that. Officers interceded. They tried lights and sirens. He didn't pull over right away. He's demonstrating, I got nothing to lose kind of attitude here. The victim is understandably frightened for her well-being. He hunted her down when she tried to escape a domestic violence situation and go to her mother's house, so he went to her mother's house, waited in the parking lot for hours. She's extremely frightened, and she has a reason to be. I would ask if I could put on the testimony of the
Well,
detective.
if, well, it's not going to be necessary. I mean, I'm going to deny the motion. And the order that's previously in effect with those findings remain in effect. However, I am going to order that your client be properly treated along the lines of what UH suggests. I know the jail's not going to like it, but that's too bad, okay? So I'm going to issue an order which is going to have them comply with the course of treatment as recommended by the doctor at, or who was it? Consuela Albright from UH. So that's how I'm going to do this. We're going to set this for trial, jury trial, on January 9th at 8 o'clock. And that's going to be about as far as we can go with the constraints of the speedy trial statute.
Is that a time issue? Do you know what it is? Okay.
Is there anything further, Ms.
Nothing
Mulligan?
further.
All right. Mr. Mulligan, anything further?
Thank you.
All right, we're adjourned.
All right.
If he retired, he didn't seem so long.